So 1:59, I'll just get started.
Sure.
All right. Well, welcome to this patent workshop, Hacking the Patent Code. If anybody needs a handout that comes late, it's going to be over here. So first of all, it's great to be in Silicon Valley. I looked at some of the people that RSVP. I don't know if those people are here, but some of the companies that are here or might be here include things like better breast pumps, algo trading for consumers, co-pilots for advanced care, and so on. So quite a variety of different technologies here. Also, I noticed that about half the people here are the ones that are RSVP'd have already filed a patent, and another half have never done anything with patents. So this talk might be a bit bipolar. I'm going to try to cover both extremes here. So first of all, what qualifies me to give this talk? Well, my personal background, I know some of the companies that RSVP'd had MIT connections. I graduated from MIT, got trained at a patent law firm, and I've been involved with startups since 2009 as a patent consultant and a patent agent. The one thing, disclaimer, I have lawyers too. My lawyers have told me that this is not legal advice, it's purely educational. So nothing I'm telling you is legal advice. So a bit of background, did I choose the right profession? Well, the MPEP, which is what the federal government publishes for patent rules and regulations, is about this thick, and it's about 2,000 pages, 11-point font, single-spaced, double-sided. But my dad's medical books are that tall. So that leaves a lot of room in my brain, in my empty brain space, for creativity. And believe it or not, in patents, there's a lot of room for creativity. Many people don't realize that. So my patent experience is, I personally have 20 patents that have been now licensed by major companies. I've also worked with some big companies like Pioneer Energy, which have gone on to deploy their technology to oil and gas fields around the United States. And we did their patents, as well as biotech. I've also been involved in many other companies. We'll talk about some case studies at the very end. How do companies benefit from patents? Well, these are just anecdotes. But anecdotally, it gives you attention, it gives you higher valuations. This sounds like hand waving. Well, there was actually a study that was just done by Harvard Business School that actually quantified the benefits of a patent to a startup. So this study found that up to 51% increase in sales growth from a patent for a startup within the next 3 to 5 years after their initial patent is approved. They also found that a delay in the first patent being approved, even though it's eventually being approved, led to a negatively impacted their success rate. They also found that each year of delay in getting a patent reduced the startup's sales growth by 28% over a period of 5 years. So this was just quantified by Harvard Business School. This is a correlation, not a causation. So how do they explain these findings? Well, approval of a patent application can increase a startup's chances of getting funding, especially they found if it's a first-time inventor or first-time entrepreneur. They found that patents facilitate the startup's access to investors by mitigating information frictions, and they alleviate concerns about being able to monetize their inventions. So now that you guys are probably here because you're interested in patents for startups, I assume. So that was just the background information. In the rest of my talk, I'm going to address what is patentable, what is a patent, what is a claim, what makes something novel and non-obvious, and conclude with case studies. Now, I probably have been working with patents for startups specifically for maybe 10 years. So I'm not going to be rambling on for the 5 hours, although I probably could. So therefore, if you have a question, then you should interrupt me, because that would be more useful, I think. And again, for those that might have already filed a patent, if some of this is too obvious, then let me know. We can fast forward through it. So what is patentable? So first of all, what is patentable is determined by Congress. And that is because the power to promote science and useful arts was given to Congress by the United States Constitution. So everything I'm telling you is something that was decided by Congress. The first patent statute was actually passed by a very famous man, Thomas Jefferson, who introduced the patent bill as the third bill in the first Congress. And this just shows you how important they thought patents were, the founders. Their second bill that they introduced was about coining money. So what is patentable? Well, Congress gets to decide what is patentable, and Congress has said that any new and useful process, machine, manufacture, composition of matter, or any improvement on it would be patentable. But what does this mean? Well, Congress gets to say what's patentable, but the Supreme Court gets to explain what Congress meant. So the Supreme Court has actually said that Congress intended that anything under the sun that is made by man would be patentable. So things as ridiculous as tricycle lawnmowers and methods of concealing partial baldness have all been patented, believe it or not. And in this case, in which the Supreme Court said that Congress meant almost anything to be patentable, they actually held that genetically modified microorganisms was patentable. That doesn't mean that everything is patentable. So there are some things that are not patentable. So things like laws of nature, physical phenomena, abstract ideas have been held not to be patentable. So if you find a new mineral or you discover a new plant growing in the wild, you can't get a patent on it. So similarly, things like Einstein's equations and Newton couldn't patent gravity, etc., etc. More precisely, mathematical algorithms per se as algorithms are not patentable, and that's because that would be considered an abstract idea, a mental thought. You can't get a patent on it. And most recently, you might have read about the Supreme Court case Alice, which went to the Supreme Court in 2014. The Supreme Court determined that a generic implementation of an abstract idea is also not patentable. So just implementing an abstract idea on well-known technology like processors and memories is not patentable. The Supreme Court developed a two-part test, which if people are more advanced and they want to have a question, we can talk about it at the very end. But this two-part test is actually, even the patent office can't really figure out how to apply it consistently. But there is actually a two-part test to determine what is an abstract idea versus what is a patentable invention. And if people are interested, which you might be, we can talk about that at the very end. But it has to do with an abstract idea has to have an inventive step before it can give rise to a patentable idea. I noticed that the people that RSVP'd, I don't know if they're here, had some of them were in the area of electronic health and biotech, etc. So we have a slide here on some biotech-related Supreme Court cases that preceded the Alice one in 2013. The Supreme Court actually changed the law, and it determined that genetic sequences are not patentable. So previously, if you were the first to sequence a genetic sequence, because the argument being that you were the first to isolate it from nature, you were entitled to a patent. That is no more the case. So in the Supreme Court case, Association for Molecular Pathology versus Myriad Genetics, Supreme Court invalidated a patent that actually came out of a startup, which was a spin-out from University of Utah. They were the first ones to sequence BRCA1, BRCA2, which are breast cancer genes. And they then developed a diagnostic test to determine the likelihood that someone would develop breast cancer. And they were the first ones to sequence it, and they were granted a patent. But the Supreme Court said that merely isolating a DNA sequence from nature does not give rise to a patentable invention. Similarly, on the other hand, they did say that a synthetically produced DNA sequence, like a complementary DNA, could still be eligible for patenting. They also, in a different case, a year before, they also held that a diagnostic method that relies on a natural correlation is also not patentable. So the Supreme Court has been finding a lot of things not patentable recently, so it makes my job more interesting. But it also creates a lot of some uncertainty for people. Let's see. It actually is patent, despite everything that I've said, it actually is possible to get a patent on software, a valid patent on software. One criteria, this is not, the Supreme Court has said this is not the only criteria, but one criteria for a software patent is classifying it as a concrete machine that produces a useful, concrete, and tangible result. We can talk about in more detail what it means in practice, because this is all fancy legal speak, but in practice for engineers we can talk about what that means. But it is possible to still get a patent on software. So any questions about what is patentable? What is a patent? Well, you have in your hands perhaps what might be the most famous patent for Stanford, which is the first Google patent. This is the patent on PageRank. This patent only names Larry Page as the inventor, so he must be the real brains behind the operation. I don't know. It's owned by Stanford, but it's licensed by Google. So what is this patent that you hold in your hands? Well, first of all, it's a right to exclude somebody from doing something. It's not a positive right, it's a negative right. It's the right to exclude somebody else in the United States from making, using, selling, offering for sale, or importing into the United States the invention that's claimed in the claims which are at the end of the patent. The important thing about patents that some engineers might get confused about is it's not a right to do anything per se. It's not a right to practice not even a right to practice your own invention. It's not a right to violate any laws. So just because your patent says something, you might still be violating a law. Like your patent might be for a very, very fast automobile. It doesn't give you the right to violate speeding laws, etc. It's not the right to exclude, not a right to export the invention, not even a right to import the invention. It's only the right to exclude others from practicing your invention in those categories that I described. The people that are coming here new, did you get handouts? Okay, so we have handouts over here. So the patent, is this too basic for people, or is this good? So the patent includes a specification, which is the detailed written description of the invention and how to make and use it. The specification includes a background, summary, detailed description, and usually examples. You need to have drawings if they are necessary to describe the invention. So if it's a purely chemical patent, you might not need drawings. Most important part is the claims, which come at the very end of the specification, which is at the very end of the document. Any questions about the Google patent or the parts of a patent, or what a patent is? No questions. What is a claim? Well, a claim, if you remember, the patent right gives you the right to exclude others from doing what? But doing what's in the claim, not something that's written in your head, or not something that's written in the description. It's what's in the claim. So there are many types of claims, but all types of claims have to fall into one of these four categories. It has to be a process, a machine, an article, or a composition of matter, which could be practically anything, or improvements on these four categories. So what's an example of a process claim? Well, this Google patent you're holding in your hands actually has a process claim. So the first claim in the Google patent, it's a software patent, but it has a process claim. So if you open claim 1, you go to the very end, column 8, you'll see the first Google patent is a computer-implemented method of storing a plurality of linked objects. And you can see, since it's a method claim, each paragraph in the claim is a step. So we're in column, they don't have page numbers, but we have column numbers, column 8. Bottom of column 8, which is on the second to last page. The weird thing about patents, they don't have page numbers, they only have column numbers. So therefore, the Google patent includes a method claim, but if you look to the next page, it has another method claim, but if you look at claim 18, which is on column 10, the Google patent also includes an article claim. It has a computer-readable medium claim, which is a software article. So there are different ways to claim software. In the Google patent, we see at least two ways. One is as a method, which falls under the category of a process. Another is as an article, a software product. So an article would be the storage medium that carries the software. In your case, because we have cloud technology these days, it's not going to be a CD-ROM, it's going to be the server that holds the software. So during prosecution, what happens is you amend. So if this is what you're claiming, a claim is like a fence around what is your property right. So if you draw the fence like this, then the examiner's job is to find if there's been any sheep grazing on that land. If there is, you can't claim it because you weren't the first one there. So each little red dot is a piece of prior art that the examiner found. So, like in the olden days when people went out west, if you were the first one to get to a piece of land, you can claim it. But if there was someone there already, you couldn't claim it. So if there's someone there already, you have to modify your fence. So that's what happens during patent prosecution. You draw the fence so that you're not capturing people's land that doesn't belong to you. Another example of a patent claim is a composition of matter claim for chemistry. So a composition comprising a solid, a liquid, and a gas, that's an example of an independent claim. Dependent claims are ones that depend from an independent claim but add more matter to it. Another example of a process claim is in biotech would be a method for producing a protein XYZ. So let's look at the Google claim 1, or rather Stanford's claim, which is licensed by Google. It has 1, 2, 3 steps. So that's analogous to the apparatus or the method comprising steps A, B, and C. So in order to infringe the Stanford claim, which is licensed by Google, you would need to practice at least those steps. So at least A, B, and C. What that means is you can have more. You can always do more stuff. So if you do A, B, C, D, E, F, and G, H, Y, Z, you would still have infringement. But if you just did the first 2 steps of the Stanford patent, but not the third one, there would be no infringement. And prior art is the same exact way. In order for prior art to invalidate your claim, it has to have all steps that are in the claim. But it could have more steps too. So if you guys are mathematicians, the patent defines, it's a negative right, so it defines the minimum set, and logically you can see why there would be no other way to do it. If you think about that for a few minutes. Now, as I said, a patent is the right to exclude others, but when my patents were being infringed, I couldn't call 911 and say, hey, send the cops to those people, put them in jail. That's not how it works. You have the right to exclude others, but your right is really a right for a civil action, which is a lawsuit, in the United States District Court. And you can recover lost profits, reasonable royalties. You can get treble damages in the cases of willful infringement. And you might be able to get the court to issue an injunction, which means stop that company from doing whatever they're doing. But there's no patent police. It's not a crime to infringe a patent. They're not going to go to jail. It would be damages in the form of monetary damages or an injunction. Any questions about any of that? This is where it gets really technical. So if you have any basic questions, you should ask them now. No questions? Nobody? Yes?
What happens in an industry like cannabis that is legal in certain places but not legal federally?
So that's a great question. So as I said, the patent doesn't give you the right to practice your cannabis invention. So you can, but if someone else practices it, you can certainly sue them for infringing your patent. And the fact that they might be infringing another federal law is not really relevant. A lot of cannabis inventions are products that help cannabis, so they're not illegal in any sense at all. Like, for example, one of my clients that I talked to, a potential client that I talked to, was evaluating the quality of the marijuana. That's a machine that's like a scientific instrument. It's not infringing any marijuana laws. So most cannabis inventions don't infringe any marijuana laws. Anybody had any other questions? All right. This is where it gets really complicated, because I'm going to go into minutiae of the legal laws for what it makes something novel and non-obvious, because this is where people get the most questions, I think, for inventors. So first of all, Congress rarely makes things simpler, but in this case they actually did. They passed a law in 2011, which went into effect in 2013. Before they passed this law, what was prior art was very complicated because it had been amended since the time of Thomas Jefferson, and they amended it and they had all kinds of exceptions, this and that. Nowadays, they deleted everything and they started from scratch. So basically, the bottom line is, if it's known out there, it's prior art. So prior uses, in the public uses, printed publications. So an example is the key to being publicly accessible. A printed publication is public accessibility. This would apply to anything. So, and this is an example. Let's say your invention was invented by Sergei blah 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 in the Soviet Union in 1959. And that person wrote up a PhD thesis and shelved it away. And he had their name on it, and it was put into the Soviet library in the basement, and it was never seen again because there was the Cold War, etc. Well, is that public knowledge? Well, it depends. If that thesis was only indexed by the name and the title, it would not be considered publicly accessible. But if the exact same scenario, but that Russian academic library indexed it by subject matter, that is considered publicly accessible. The fact that not a single person in the entire world ever read that thesis does not matter. If it was accessible in theory by subject matter, it's considered publicly accessible. So this just gives you two possible extremes. So basically, what is prior art? Is two types of prior art. One is other people's work. So other people's work is prior art if it was available to the public before the effective filing date of your invention. So like I explained just now, available to the public doesn't mean that anybody actually looked at it. It just means that it was potentially accessible by at least one member of the public before the effective filing date. Subject to the exceptions of your own prior art, which we'll get to. Similarly, any claimed invention that was disclosed in a patent or patent application that was filed with an earlier filing date than yours, which names somebody other than you as an inventor, is also prior art. That's it. Nothing else to it. Before, I used to have a ginormous slide that had like 20 different rules and exceptions and this and that. But this is, for other people's work, this is what prior art is. Anything that was available before your filing date, publicly available, or anything in a patent or patent publication that was an earlier filing date than your filing date. That's it. Earliest effective filing date has to do with claiming priority, etc. Any questions on what it counts as other people's prior art? Congress made our life simpler, for once. Any questions? Yes?
How was it before that was passed?
Before this was passed, there were A, B, C, D, E, F, G. There were A, B, C, D, E, F. There were 7 different categories of prior art. Each one was separate and had different language, and there were thousands of case laws that were trying to interpret what exactly was meant by that. Now it's simplified. There's much less ambiguity in this language than in the old language. But there are exceptions. There are exceptions for your own work. So your own work is only prior art if it was disclosed more than a year ago. So this category applies to everything, whether it's your own work or other people's work. But if it's your own work, there are these 2 exceptions. The 2 exceptions are, if you disclose it less than a year ago, before your effective filing date, it is not prior art if it was disclosed either by you or by someone that got it from you. So let's say I made up a new invention. I had an improvement on a Google patent, and I just came up with it. I have a superior method of PageRank that uses correlations of documents, and I just told you what it is right now. Well, if any of you went out tomorrow and told it to the public, and they went out and told it to the public, if I filed my patent at least, what is today, May 5th? If I filed it at least on May 5th, 2017, none of that stuff would be prior art against me. Because what I said is not prior art for a year. Anything that people got from me is also not prior art, even if they repeat it to a lot of other people. But after that 1 year expires, good luck. So this is a really important thing. people don't realize, oh, it's not fair, but this is my own invention. Well, the purpose of a patent is to incentivize you to disclose things to the public to get a monopoly right for a limited time. If you've already disclosed it to the public and a year has passed, you've given up your right to get a patent. There's nothing fair or unfair about it. It's just the way it is. Disclosures in the U.S. patent, the other exception is if you file your own patent application and it's not prior art if the effective filing date was prior to that effective filing date, it was publicly disclosed by the inventors, or the disclosure was obtained directly or indirectly from any of the inventors, or it was subject to a common licensing agreement, common research agreement. So same kind of thing. So public disclosures and patents, your own patents have an exception. How do you search for prior art? You should search for your own prior art. You know your technology better than I do, I hope. So you should search using Google Patents, Google Scholar. Those are the best. Free patents online can search is a good search. Patent Monk is actually down now, so just disregard that. USPTO is not very good. I don't recommend using their search. Of course, your knowledge of what you know is relevant too. So if you know about some other papers, then you should evaluate if those disclose your invention. So what I said before was what is known. What is known? What is known is if it came before by somebody else or if it came from you more than a year ago. But what if something is not known, but what makes it not obvious? Well, just because something is not known doesn't mean you get a patent. And this is called obviousness. Initially, obviousness was something the Supreme Court said applies, because the Supreme Court said in a very old case that if something is only a small variation, that it's an obvious variation, you can't get a patent. Well, Congress thought this was a good idea, so they wrote up their own version of the same thing. So you're not entitled to a patent if the difference between what you want to patent and the prior art is such that that difference would have been obvious to a person having skill in the art. Now, it's up to the courts to explain what Congress means. So in one famous case in 1966, the Supreme Court explained that an invention, even though it is new in the sense that it has never been done before, you might still not be able to get a patent if the difference between the new thing and what was known before is not considered sufficiently great to warrant a patent. If that sounds very subjective to you, well, guess what? It is subjective. So one examiner might have one opinion, another examiner have another opinion. The patent office will never admit this. They'll never admit it. The patent office is uniform. Nobody ever disagrees with the patent office. But for practical purposes, we know the patent examiners are human beings, so they're going to disagree. So to some extent, whether or not you get a patent for something that might be borderline might depend on the examiner. But the bottom line, that's the truth. So the modern obviousness framework is you have to evaluate the invention based on what is known, the background. So the scope and content of the prior art. That's all the references that qualify as prior art would fall under that. What is the difference between the prior art and your invention? What is the level of skill in the art? So for example, if you're doing a chemical invention, ordinary skill in the art would be a PhD chemist. Ordinary skill in the art for a shoemaker would be different. So what would make the same incremental difference might be obvious in one field and not obvious in another, depending on the context. Now, there are secondary considerations of non-obviousness, and we've used it sometimes. Probably 20% of the time we have to rely on these. Secondary consideration means what are other reasons that your invention is non-obvious, specific reasons. So an example of that is commercial success. So let's say you come up with a gizmo, you come up with PageRank. And if you think about it, PageRank is really just a linking of documents and a known calculation of these might have been stapled. Oh no, they're stapled correctly. Might have been a linking of documents, and you're using a matrix equation, which is well known to calculate it, and the examiner says, "Oh, it's obvious." Well, if the examiner says it's obvious, One reason that your invention might be non-obvious is that you have commercial success. So if you've implemented your invention and it has commercial success, that's a reason why your invention is not obvious. If there was long felt and unsolved need, that might be another reason why your invention is not obvious. Failure of others. So if other people have tried to solve that problem and failed, this is especially relevant in biotech or chemistry, they failed. That would be another reason your invention is not obvious. So in that case, you present the evidence to the examiner. These are all the reasons why my invention is not obvious. It's commercially successful. Long felt unsolved need. Failure of others. And then the examiner has to reconsider their position whether, in light of all that evidence, if they they still consider your invention non-obvious. Obvious, rather. Usually, if you have all this evidence, usually you can convince the examiner. Oh, and by the way, before I get to case studies, in the United States of America, the primary examiner is about as close to a total despot as we get. And that's because if you're a primary examiner, you're a complete total despot. There is no one above you that has to approve any of your work. So if you're a primary examiner, and about I think 20 or 30% of examiners are primary, and you approve the applicant's patent, the applicant will get a patent. You will get a monopoly under the United States of America just because this one guy in the patent office said you deserve one. So they're as close as a total dictator as it comes in the United States, which is kind of interesting if you think about it. Supervisors don't have to approve anything the primary does, etc. They also have the authority to negotiate. So therefore, if you get a primary examiner, it's sometimes easier because if you convince that one person, you get a patent. If you can't convince them, you got to go to the Board of Appeals. Now, any questions about what's patentable and what is novel, what is non-obvious?
Just stepping from your last point, we had just recently filed an application for a toy.
Yes.
Our patent lawyer said, don't worry, I'm going to call the examiner ahead of time. He knows me, we're good friends. And this was it appeared that the relationship that lawyers have with the examiner is really important. I was curious if you could touch on that.
You're mudsling or something.
Oh, Mudwatch.
Mudwatch. You teach kids science through toys. Yay! Woohoo! So the bottom line is, it's like anything else when you're dealing with a human being. Fundamentally, the objectiveness has to carry the day, and there are checks and balances. So even though the examiner is a total despot, primary examiner is, there are checks and balances. For example, people don't become primary examiners unless they're reasonable. And the way people get promoted at the patent office is because they're reasonable, they follow the law. Even if the examiner somehow squeaked through the system and was a total jerk and got through, get promoted, if they get rejected and you appeal it to the Board of Appeals and they lose and they keep doing that, then their supervisor might think twice about promoting them to the next level. So the fact of the matter is, it's just like anything else that involves human beings. It's supposed to be objective, but there are a lot of human elements to it. But knowing the examiner personally should not affect the outcome of your case. But what it could do is it might speed it up a little bit. But it should not affect the objective outcome of your case. I don't know what else to say. It's just like if you get stopped for a speeding ticket. Might you talk yourself way out of for the speeding ticket? Yeah, absolutely. It's like anything else. So to some extent, having experience is what matters most. Not necessarily do you know that specific examiner. What matters the most is the experience. The reason the experience matters is because you can explain it to the examiner in a way and explain all the rules in a way that they get it. That's why experience matters. But also creativity matters too. So it's almost like anything else. Now, case studies. So one of the companies that was part of StartX incubator, Prediction.io, Simon is not here today because he got acquired. So his company got acquired by Salesforce a month and a half ago or so. And what the case study here is, if you filed accelerated patents, you can get them quickly. So Simon Chen started his company 2 years ago. If he had filed a regular patent, he probably would not have even heard from the examiner yet, and it wouldn't have had any time to impact his acquisition. But because he did the accelerated patent route, he was able to get 2 patents before the acquisition, and it helped him negotiate his license fees and negotiate his acquisition valuations, etc. Another client, Pioneer Energy, was able to take patents and leverage it to raise millions and millions of dollars, and they needed that because they were building high technology solutions for oil and gas. One of these machines I think cost $30 million in R&D, so they couldn't even get the product out there until they raised millions of dollars. Why would anyone give them millions of dollars? Well, the patents helped them. And that's me. I got invited to give to their factory opening. Does anybody know who? That's my friend Song, who used to work with me. Do you know who that person is next to me? That's Hickenlooper. He's the governor of Colorado right now. He's one of the few governors that was re-elected in 2014. He's one of the few Democratic governors who was re-elected in 2014. Another client is another case study. What if you can't get a utility patent? Well, in that case, you might benefit from a design patent. This is something that some clients have learned. Sometimes you just can't get a utility patent. Your invention might be a blockbuster, but it might be something that somebody already thought of 100 years ago, but you just did better marketing, or the timing was wrong 100 years ago. So these girls invented a reusable underwear that also acts as a pad, and they were selling millions and millions of these things, and they were also using it to get products out to the third world for girls that couldn't afford these types of products. But the utility patent was very difficult for them to get. We're still trying to get it. But in the meantime, we got them a design patent. So the design patent allows them to claim that it was patented. So if you can see on their product packaging, they say patented. I don't know if this has a pointer, but you can see it says that their product is patented. If you get a design patent, you're entitled to say your product is patented. What is a design patent? We haven't really talked about it, and all the rules that I explained earlier apply to design patents, but the main difference is a design patent covers the ornamental appearance of an article, which could also be a GUI. Computer GUI would be an example of an article. So Mixbook is another Silicon Valley company, and they got design patents on their photo book exterior appearance. They got a design patent on their GUI. Design patents are really good for protecting literal copycats, because it's very easy to see if someone infringes a design patent because just by looking at it. You don't need to go under the hood and look at the functionality. But other than that, one critical difference about protecting appearance versus functionality, all the other rules that I explained, they all apply. So prior art is the same, almost everything is the same. Main difference is claiming priority, you only have 6 months. But that's pretty much the only difference. Everything else is the same about design patents, and as you can see, you can imagine some products have both. You can have a functional usefulness to it, like these underwear have functional usefulness to it in the way their layer fabrics are designed. So they still have a utility patent on that that's pending, but they also have an ornamental appearance to them, and so most products qualify for both. So I think I already explained what the tips are from my own experience. Accelerated patents make a sense for startups. If you're IBM and you already have 200 patents, another one might not make any difference to you, so you might spread it out over years. But for a startup that you might need to raise money or might have an acquisition offers, having the patents there is just an extra leverage. It might be not the number one thing. Number one thing is always your team, your technology, but it's up there. I would say it's usually the top 5 to 10 things that investors look at. I would recommend you to use agents or attorneys, if you like, who understand the technology. Clear communications. Oh, it looks like my MacBook's about to die. You should avoid rejections by looking at prior art searches thoroughly yourself, and design patents. At the end of the day, if you can't get a utility patent, some people are not entitled to one, they can't get it. You should consider design patents. Any questions about the case studies? All right. So first of all, concluding random comments. First of all, your U.S. patent is only valid in the U.S. It's kind of obvious. It's not valid anywhere else. The closest thing, there's no such thing as an international patent. The closest thing is an international application, which gives you the right to file patents abroad from another 18 months later. But there's no such thing as an international patent currently. The closest thing to an international patent is a European patent. You could get a patent in the European Patent Office, which would cover all the countries of Europe. Other thing to remember, for foreign countries, you don't have the 1-year bar usually that you have in the US, which means you have to file before you make a public disclosure. So if I was to disclose something today, I would have a year to file in the US, but I would not have a year to file anywhere else. That's something to keep in mind. Which means I would be entitled to a patent in the US within a year, but I could not file anywhere else internationally. Now, there's one last thing I want to go through. This is important for engineers, and I left it to the very end because it's kind of pie in the sky type stuff. I wanted to explain this because a lot of engineers and scientists, they say, oh, but it's not fair that you can patent software. This is not fair, this is not fair. Well, I want to make a distinction too. Natural law versus natural philosophy. So natural law, what kind of questions do people ask in natural law? So, what is the speed of light? It's 299 million meters per second in vacuum. You can design an experiment, and you can conduct the experiment, and almost everybody will agree what the speed of light in vacuum is. Oh, everybody agrees. Another question, a different type of question is, why does the universe exist? Well, we might never get an answer to that question. I don't know, we might. But the same kind of distinction applies with respect to patents and law in general. Fortunately, civics education is pretty poor, so sometimes this slide might be obvious to some of you, but everything I've told you about is about man-made law. It's not about public policy. So one question in man-made law is, what is the speed limit in Palo Alto? Well, I actually did 5 minutes of, or less than that, of legal research on the internet, and I found that in the state of California, the speed limit is 25 miles per hour within a business or residential area unless posted otherwise. Another question would be, what should be the minimum speed limit? What should be the minimum drinking age? Should California have raised its smoking age to 21, etc.? Those questions we can debate on forever. Similarly, so just to conclude, this talk was about just what is about patentable under the current law. I did not address anything about should we have software patents, should we not have software patents, should biotechnology inventions be public domain, etc. So that's the conclusion of my talk. I don't think I need to go through this. I didn't see anyone fall asleep, so I'll skip through that. So the only thing is, I would like to end with Socratic dialogue, which is, are patents and copyrights morally justified? You guys can think about that at your own leisure. But keep in mind, this question falls under this category of things with the many question marks. Doesn't fall under the first category. And there's an interesting article, and there's millions of articles written on the internet about this, but this is an interesting article from 1990, so people have not stopped thinking about it. All right, thanks. And of course, there's questions, and I have backup slides if you guys need it. Yes?
What advice do you have for controlling patent costs? Do you want me to tell you the company?
Yeah, tell me.
Or do you want to guess?
Fintech. No?
No, Hancock Medical.
Hancock Medical, okay.
Devices. So
All right.
I've done a lot of medical device patents, but it's always extremely painful, the huge proportion of precious early stage money I raise that has to go to patent attorneys.
Good question. One thing you can do is you can offload some of the work from the patent attorney or agent onto yourself. So for example, doing thorough prior research yourself.
Yeah.
Being reasonable with what kind of claims you demand from the patent attorney, or patent agent. So I don't want to be a walking advertisement for myself, so I can talk to you on the side later. But one thing that I have clients that come to me, they say they would like a patent on what amounts to a calendar, or they want a patent on what amounts to genetic testing. And if you try to get a patent that's
Don't be unreasonably broad.
don't be unreasonably broad, especially with your first patent claims. That's another thing you can do. So attorneys that are used to working with large companies are used to the strategy of going really broad and then negotiating down. And that strategy is perfectly reasonable. In the long term, if you're filing 250 patents, that strategy might actually be slightly more economical for you. For a startup that needs to get the patent quicker, my strategy is to start narrow and then go broad with future patents. So that strategy does not make sense for IBM, but it makes a lot of sense for a startup because they can get a patent quickly and then they can file follow-on patents that are broader once they've raised the money. Once they have the money to negotiate with the examiner till the cows come home. So those are, I gave 3 strategies, I think. Offload the work to yourself. Pursue, don't be unreasonable with the kind of claims you demand of your attorney or patent agent, and pursue narrower claims, even more narrow claims in the beginning, and pursue broader claims later. Does that answer your question?
Yeah.
Design patents are also really, really cheap. If you get a design patent, you can write on your marketing literature your thing is patented. I don't know if you qualify for a design patent. I don't know if you're a consumer or not, consumer device. Design patents are really cheap.
They don't offer much protection.
That's true, but a lot of people don't know that. And that's also not true if you do it right. So for example, you know about the Apple versus Samsung case? That was a $100 million verdict. Now it's going to the Supreme Court. Nobody knows what's going to happen. But a lot of patents for an early stage startup is advertising. And you can advertise yourself just as well with a design patent as you can with a utility patent. Because you can say your thing is patented. Which is what the girls that have the multi-million-dollar underwear sales are doing. Every article that they write on the internet, and they're getting a lot of press. They're all over Facebook, all the social media, all the press. All their press writes their product is patented, and it is patented. Nobody is going to look into the minutia. Is it a design patent? Is it a utility patent? Is it a narrow patent? Is it a broad patent? Nobody is looking. But they're getting a lot of media attention, and that helps them to be able to say that their thing is patented. And design patents also protect literal copycats. So for literal copycats, it's very useful. You raising your hand? No? All right. What else? No other questions? All right.
Okay.
Thanks for coming. Anybody need a handout? Google patent handout? You can have this. Do you want this? Yes.
Thank you very much.
Thanks. My contact information is here. If you guys need to contact me. Oh, thanks. Oh, you have a small one too.
Yes, those are the best.
Oh yeah, for our WhatsApp. Okay, thanks.
It's a video news aggregator.
Oh, okay, cool.
We haven't filed